Ibrahim has just purchased a registered freehold estate. The contracts are exchanged, the purchase money is transferred, and he crosses the threshold of his new property. But instead of an empty house, he walks into a complicated legal web. Inside, he finds Teresa. She is the seller's civil partner. She didn't contribute to the purchase price, but she insists she has a statutory right to stay in the home. Outside, a neighbor named Vernon is driving his car straight across Ibrahim's new driveway. Vernon claims the previous owner granted him a right-of-way by deed last year. Then the mail arrives. It contains a notice from Barclays Bank. The seller defaulted on a massive mortgage, and the bank holds a charge over the property. Finally, Ibrahim checks the back garden. Another neighbor, Wendy, is occupying a fenced-off section of the lawn. She holds a written 5-year lease signed earlier this year. 4 different third parties claim an interest in Ibrahim's land. Property law requires us to determine exactly which of these individuals legally binds the new owner and who faces immediate eviction. To solve this, we rely on the primary statutory shield for property buyers, Section 29 of the Land Registration Act 2002. Section 29 specifically protects a purchaser for valuable consideration. Because Ibrahim paid market value for the estate, meaning he didn't receive it as a gift or through nominal consideration, he qualifies for this protection. The rule is strictly applied. Ibrahim takes the legal estate subject only to entries already appearing on the official register, plus a narrow category of unrecorded overriding interests. Any right falling outside those parameters is postponed. It loses its priority. This flowchart illustrates the required legal methodology. To determine enforceability, we must force every claimant into a distinct statutory category shown at the top. These 3 dictate the outcome: registrable dispositions under Section 27, interests affecting a registered estate, and overriding interests. If you miscategorize a third-party right within this matrix, your entire analysis of priority will collapse. We begin with the strongest statutory bucket, registrable dispositions governed by Section 27 of the LRA 2002. The statute mandates that certain dispositions of registered land do not transfer the legal estate until they are completed by registration. Until that administrative step occurs, they do not take effect at law. Looking at the chart's left-hand column, we can process Vernon. His right-of-way is an express easement by deed, listed under Section 27. The Barclays Bank mortgage follows the same path. A legal charge is explicitly defined as a registrable disposition. Priority here is a matter of strict timing. For Vernon and Barclays to bind Ibrahim, their rights must have been entered onto the charges register of the property before the date Ibrahim is registered as the new owner. Note the specificity of the law. Vernon's easement is expressly granted by deed. If his easement had been created by implication or prescription, it would bypass Section 27 entirely and require a completely different statutory test. Assuming Vernon and Barclays properly filed their paperwork, they survive. They successfully populated the land register, placing Ibrahim on official notice of their existence. Next, we test the second bucket, interests affecting a registered estate under Section 32. This category catches the vulnerable equities. It includes non-trust equitable interests, estate contracts like options to purchase, and rights to occupy under the Family Law Act. This brings us to Teresa. Because she made 0 financial contribution to the purchase price of the property, she does not hold an equitable interest under an implied trust. Her sole protection is a statutory right to occupy the civil partnership home, granted by Section 30 of the Family Law Act 1996. To bind a purchaser, Teresa was legally required to protect this right by entering a Section 32 notice on the charges register. She failed to do this. You might assume her physical presence in the house offers a backup fence. It does not. Section 31, subsection 10, paragraph B of the Family Law Act explicitly prevents family occupation rights from taking effect as overriding interests. The registered system operates ruthlessly against unprotected rights. Because Teresa lacked a registered notice, Section 29 postpones her interest. Ibrahim takes the property entirely free of her right, and Teresa faces eviction. Now we evaluate Wendy. She holds a 5-year written lease on the garden. This is an equitable estate contract. Like Teresa, Wendy failed to enter a Section 32 notice on the register. However, Wendy has access to the LRA 2002's fail-safe mechanism, Schedule 3, Paragraph 2, which protects unregistered interests which override. To trigger this protection, Wendy must prove two things. She must hold a proprietary interest in the land, and she must be in actual occupation. A lease is a recognized proprietary interest. The legal test, therefore, hinges entirely on her occupation. This text block summarizes the foundational House of Lords decision in Williams and Glyn's Bank v. Boland. Lord Wilberforce stated that actual occupation requires a physical presence, interpreting the phrase as ordinary words of plain English, rather than a special legal doctrine. The courts have strictly defined the limits of this physical presence. In Abbey National v. Cann, the House of Lords ruled that merely sending a relative to move in furniture and put up curtains did not constitute actual residential occupation. It was only a preparatory step. Yet the nature of the property matters. In Lloyds Bank v. Rossett, a semi-derelict property was deemed occupied because the claimant was regularly visiting the site to supervise building contractors. The courts will even accommodate temporary absence. In Link Lending v. Bustard, the claimant was absent for over a year in psychiatric care. But because her possessions remained in the home, bills were paid on her behalf, and she expressed a clear intent to return. She was legally held to be in actual occupation. Schedule 3 limits this protection with two strict caveats. The occupation must exist at the exact time of the disposition, meaning the date of completion, and it must be obvious on a reasonably careful inspection of the land. Wendy is physically present in the garden, fulfilling Lord Wilberforce's plain English test. Her occupation was obvious, and it existed at the time of completion. Her equitable lease shatters the mirror of the official register, forcing Ibrahim to honor her tenancy for the remainder of its 5-year term. There is exactly one scenario where a purchaser can defeat a claimant who holds a proprietary right and is in actual occupation. It relies on a mechanism called overreaching, established under Sections 2 and 27 of the Law of Property Act 1925. Overreaching has a precise mechanical trigger. The purchaser must pay the purchase money to a minimum of 2 trustees. This mechanism only applies to beneficial interests behind a trust, like the one held by Mrs. Boland. It cannot be used to defeat an equitable leasehold interest like Wendy's. When purchase money is paid to 2 or more trustees, the beneficial trust interest instantly detaches from the physical land. It attaches instead to the monetary proceeds of the sale, leaving the buyer with a completely clean title. Overreaching exists to ensure commercial certainty in property transactions. It legally transforms an unevictable occupant into a beneficiary of liquid cash. Returning to the blueprint of Ibrahim's newly purchased estate, we have our final legal verdict. Ibrahim is bound by Vernon's easement and Barclay's mortgage because they are registrable dispositions under Section 27. He is also bound by Wendy's equitable lease, which survives as an overriding interest under Schedule 3, Paragraph 2. Teresa is evicted. Her statutory Family Law Act right failed to meet the strict notice requirements of Section 32, stripping her of any legal standing against the new owner. When faced with third-party claims on an exam, execute this 4-step checklist. 1. Identify the formalities of the right. 2. Categorize the right into the correct statutory bucket. 3. Check occupation dates strictly against the date of disposition. And 4. Test if overreaching applies. Mastering this rigid categorization framework is the definitive tool for resolving human legal chaos. It provides the analytical structure required to apply the Land Registration Act with precision and achieve a first-class mark.